Musicians and performers are always caught up in the act. But do you want to be caught in an act? And this is a question that each musician, performer, or stage artist needs to answer. And therefore, on this note, it is extremely important to understand the essentials of the laws relevant to the music, performance, and stage industries. It is very crucial to understand how these laws operate and to protect your rights and know your liabilities and duties under these various laws. And today, we are going to touch upon these laws very briefly to help you get a better understanding of what you need to look into when getting into music contracts or in the performance area. Now, as you start out, the most important thing that you would really consider is the law of contracts, because the law of contracts is the law that governs all your relationships with your labels, with your managers, with your musicians, with the companies, with the event organizers, with your restaurants, venues, the works. All is a contractual relationship. And this is what governs your entire life as a musician, a performing artist, or a stage artist. Now, the first question you're going to ask me is, why is it so important to look into these laws? These laws govern the industry, govern your relationship with fellow members of the industry, with various companies and various organizations that form a part of the industry. Most of the time, it so happens that people engage into contracts without really knowing the relevance or the legal implication of these contracts. And when they approach the legal fraternity, it is often too late. And it's very difficult at that time to save a client. A very crucial thing that most people are a victim of is the Latin maxim called ignorantia juris non excusat, which in English translates as ignorance of law is no excuse. And therefore, when you get into such contracts or when you get into such agreements, it is imperative that you know the legal implications and you know the laws that govern these relationships. Another very interesting angle is music publication, production, remixing, and of course the fair use of recorded works. This is something that you need to know in terms of rights and liabilities and duties to ensure that you are not infringing somebody else's copyrights, or to make sure that nobody else is infringing your rights. Let me first take you through the constitutional provisions, and all performers always governed under the laws of freedom of speech and expression, Article 19(1)(a) of the Indian Constitution. But what you need to realize is you are also governed by the reasonable restrictions under Article 19(2). The right to protect intellectual property, the right to protect the owned works of other artists is well within the ambit of reasonable restrictions. While you expect other musicians to respect your work, you need to respect theirs as well. Moving on to the law of contracts, which I mentioned earlier. The law of contracts is very crucial to understand. In an earlier video, I've done the essentials of a valid contract. I'll share the link in the comments, but what you need to understand is how these contracts work with various agencies and what you need to look for in these contracts. The first kind of contracts that you would come across, the most obvious, are employment contracts. Employment contracts would be contracts with musicians, managers, band performers, sound rental companies, anybody, labor for that matter, anybody interested or anybody engaged with your production or your performance process. Now, what do you need to look for? Very importantly, the consideration clause, how much you are paying them or how much they are paying you if you're the employee. Another very important thing are the rights and liabilities. So if you're performing a score which is given to you, the intellectual property of that score, one, is the person who is owned by the person who has created that score, the composer of that music. Also, the liability in case of infringements of somebody else's copyright should then vest with him. So you are not liable if that score, because you are just performing out of that score, so you are not liable if that score violates or infringes a copyright. Another very important thing is if you are recording for film music, or you're part of or you own a band, it's very crucial to understand that performers that are performing for you under their engagement or employment contracts are performing for you because of the music that you have created. So the rights would vest in the creator or in the composer, and those performers would have no claim on the rights of their performance. Managers is another very, very crucial thing, or when you have artist management companies that handle your profiles or your accounts, because there is something called a contract of agency. In a contract of agency, these agents are basically doing work for you on your behalf, and you are what we call in law the principal, which means you agree to ratify and accept whatever these agents would do on your behalf and for your benefit. Therefore, the powers, the functions, the duties, and whatever is contained in that agency contract or the employment of a manager's contract should be expressly spelled out. What are your liabilities? What are his? What are the consideration clauses? What are the various aspects of his role as a manager? Therefore, you would be secured and protected against any acts that he could have committed which is beyond the scope of his agency. The next very crucial aspect that you come in contact with are performance and recording contracts. These are very important because these are very crucial. Now, when you get into performance contracts for live events, at venues, at restaurants, at hotels, at several other places that you perform, your gig needs to be covered from a legal angle. And how do you cover that? Make sure your licensing is covered. Make sure your payment clauses are covered. Make sure vendor agreements are covered, even if they're vendor agreements with third parties. Very simple thing. Are you providing the sound setup or the light setup with your performance, or is that being covered by the organizers? Who will take out the performance licenses? I will do performance licenses later in this video, but what you need to understand is who is responsible for taking out of the necessary licenses, obtaining the necessary permissions for that performance. Because you are on stage and you do not want to be in infringement or not having the requisite licenses or permissions. A very crucial thing then is the performance rights. So if it is a contract that engages you as a performer, in recording contracts you don't really have this because all the rights of the recording would be that of the producers. But in live events you would want to specify whether the performance rights are yours or that of the event company or the organizers. If you work with a TV channel or a broadcast platform, the rights of the performance, the ownership of intellectual property, acquisition of performance licenses, etc. need to be clarified. And these are clauses that you need to look into it when you're drafting a contract or when you get a contract prior to signing it. Let us now look at the laws of intellectual property rights. And intellectual property rights is a very interesting topic because intellectual property rights and intellectual property per se is just like physical property. So like you'd own a house and you'd own a car, you'd also own a copyright or a trademark. Now, if you are a band, an artist or a label or any such performer or musician that performs under a stage name or a brand name, there are two things that you need to look into, and this is in terms of a trademark. One, what you need to look into is your stage name or is your performance name or your band name somebody else's name prior in time? Are you using a name that is already being used? And if there is a trademark filed on that name, you could be liable for trademark infringement. The next thing you would want to look into is when you create a name, register a trademark on that name, because that would protect your performance name or that would protect your name on stage. The next aspect that you come up with is copyrights. Copyrights govern musical performances, recordings, sound recordings, video, film, musical scores, scripts, etc. Now, if you create music of your own, you would be extremely careful to ensure, one, that is, it is original, and two, if it is, you file a copyright on the same. This ensures that the music is purely yours. It is always safer to have a registered copyright. The next question is when it comes to the use of other people's copyrighted work. Another very important thing to understand is every song or every piece of music that is released in the public domain contains an inherent copyright in the performer or in the artist. If you are using music which is not originally yours, it is essential to check the copyrights and ensure you have the necessary licensing. If you are performing music in terms of covers or other pre-recorded works which are not originally yours, in performing such music, you would need to obtain the necessary performance licenses. Another thing to all the DJs out there, when you perform or when you play music, again, you require the necessary performance licenses because those CDs are not originally yours unless they are purely mixes which were made by you from scratch. Even in cases of remixes, whether a musician or a DJ, it is essential to have the requisite performance licenses. This is something that you need to know, and if you look at CDs, for those of you who have collector albums of CDs, take a look at the CD, and that's a very interesting thing in terms of what we call permissible use. A CD would contain a clause saying this is for private purposes only or private use only. Any public performance or broadcast would require the necessary licensing under the Copyrights Act. This means that in case you are using a CD for any commercial performance like DJing or any other broadcast purposes, you would require the necessary performance licenses and would have to pay the necessary license fee, which is the label and artist royalties that would be required to be paid under law. Going further in terms of trademarks and copyrights and broadly within the domain of intellectual property, another very crucial area to understand is infringement and then dealing with copyrights. A very simple way to understand what infringement is basically using somebody else's work without the necessary permissions or without the necessary licenses. The next question is how do you obtain these licenses, or if the work is yours, how do you give somebody else the license to use it? And there are various ways of assigning intellectual property rights or transferring copyrights. You may either sell the copyright, and this is also true for labels and music releasing companies that would buy your copyrights when they acquire the song. So you either sell the entire song, which means the song with the intellectual property rights is sold for a consideration, or it is assigned or leased on a limited purpose. That would mean that it could be a specific right only for publication and distribution, but the intellectual property is still yours. These are limited purpose assignments. These are specific rights within the intellectual property rights that are transferred for a certain consideration. Having understood the logic of intellectual property in brief, another very crucial area are certain other contracts. Non-compete agreements is very classic that sometimes you come across cases, there may be separate non-compete agreements or clauses that would restrict you. There would be non-compete clauses that would restrict you to be in direct competition with the person that you are getting into a contract with. I will tag the links to non-compete agreements and confidentiality agreements in the comments below. Non-disclosure and confidentiality agreements would also apply to musicians like it applies to corporate employees. If you are working on film production music, if you're working on music for television, if you're working on exclusive production, you may need to sign confidentiality and non-disclosure agreements with your employer, with the producer or the label to make sure that you do not disclose any confidential information or intellectual property while producing and immediately thereafter. With that, I do hope you have a brief understanding of the laws relating to musicians and performers. And the simplest way to make sure everyone's rights are protected is respect the rights of other performers and let everyone respect your rights as well.